All right, we've got the news segment here for you guys. This week we have a new guest. We've introduced you to another part of the Reload family. We have contributing editor Paul Crookston with us this week to go over some of the latest news out there. How you doing, Paul?
I'm doing well. Glad to be on here and glad to get to talk about this week's set of news.
Yeah. So what do you got for us? What's going on?
All right. So the big news this week is that the lawsuits are rolling in. After the Supreme Court's ruling in New York State Rifle and Pistol Association v. Bruen, several blue states got to work passing more gun control legislation. And gun rights proponents, unsurprisingly, have gotten to work taking them to court.
Yes. There's been a whole flood of lawsuits now. The Supreme Court blew up the gun litigation space, and now you're seeing the fallout from that in the form of these new laws and these new challenges to those new laws. We've got cases in New York, California, DC, Hawaii, right? Legal action all over the place.
Yeah, and I think New York is the star of the show here. That's where the Bruen case was, and New York legislators and the governors seem intent on doing battle with the court a bit here.
Yeah, they're certainly the epicenter, just like they were in the Bruen case, and now they didn't like the outcome of that case, and they seem poised to end right back up at the Supreme Court again, in all likelihood, over these new restrictions that they've passed. Contributing writer Jake Fogelman had a great analysis piece on this new paradigm that we're seeing that you might call shall issue, but may carry, because now a lot of these states are removing their good reason clause, although they are instituting other subjective standards as well. But in place of the old restrictions, they are now putting in far more restrictions on where you can legally carry. New York, especially, has been leading that push. Effectively, they've banned carry in, almost every piece of private property in the state, unless they sort of flip things on their head. Usually, public businesses open to the public are presumptively areas where people can carry in basically every state, except now for New York, where instead of having to put up a sign that says no guns allowed, it will be presumptively off limits, and you'll have to post a sign that says guns are allowed. So that's an interesting novel approach that they're taking, and that the governor has kind of underscored the goal of by saying, the only places it'll be legal to carry a gun in New York are some streets. This is a quote from her. And they've been sued over it now. There's already a lawsuit dealing with that part of the law. I think comes from a very controversial, kind of crazy, frankly, Republican candidate up there. But he's challenged this. I'd imagine that there will be more challenges from perhaps more serious objectors. Maybe some of the gun control groups will get involved, and they're likely to end up back in the court with that. Yeah, with what they're doing on that front.
It certainly seems like a direct challenge to the logic of Clarence Thomas's opinion, because his whole point basically boils down to, we shouldn't treat the Second Amendment like it's a different category of right. And it takes 5 seconds to think about, if there were a million caveats about where and when the First Amendment applied to you, to the point where people are talking about, can we have an online map that has live updates about which places are opening up as a possible zone where you can have a gun? And like you said, the some streets quote from Kathy Hochul, it doesn't take a legal expert to say, well, this clearly is a regime around guns that is completely different from every other right. So it's directly challenging the logic of Thomas's decision in a way that has to be intentional, I would think.
It sure seems that way. I had a whole analysis piece on this last week where where I talked about. I mean, this is just it's a message to the Supreme Court to come and get us again, I guess. Like, we don't care what you ruled last time. I mean, especially there's another lawsuit from perhaps a more established group. The Gun Owners of America is suing New York as well on their insistence in protecting the subjectivity of these permitting decisions. Because sure, they got rid of the good reason clause in name. You don't have to prove you have a specific need that's specialized in order to obtain a permit, but they double down on their good moral character clause. So now, instead of the issuing official judging whether or not you have a good reason to carry on their own subjective merits, they'll judge whether or not you have a good moral character. And they have, instead of a good reason clause, they have a good tweeter clause, is what I'm calling it.
That's good.
Which is where you have to share your social media accounts with the issuing officer, and they will determine if you are a good enough tweeter, I guess. Well, I mean, to be more serious, they're gonna look for things like threats. It's not clear. There's no standard on what they're supposed to look for or what would determine whether or not you qualify as having good moral character. California's done the same thing out there. There's also a reference process in there, sort of like job interview, where you have to provide references to people to tell the state that you are a good person in order to exercise this right. I mean, which the Supreme Court, this isn't like a privilege. This is something that they identified as a core right, part of the Second Amendment. So it remains difficult to see how subjective standards like good moral character clauses, or this social media vetting process that they've instituted that doesn't have an objective measure for what would disqualify you is going to survive a court this sort of court challenge from Gun Owners of America, which is a little more, which frankly, compared to the other two cases going on here, there's another case that was self-filed by a Second Amendment lawyer representing himself against these same good moral character clauses in New York. But the GOA suit is probably a little more likely to succeed, just because they have an actual track record. They're an organized group that has a track record of these sorts of cases and has legitimate wins over time. So anyway, New York is right back at the center of all this immediately, because frankly, they just didn't accept the one. They accepted it in the sense that they got rid of their good reason clause, but then it's actually right now, and frankly, I don't think this is going to last that long, but right now it's worse for people in New York who want to carry a gun illegally. It's harder to do it now than it was before the ruling came down, and something tells me that's not going to sit well with these Supreme Court justices.
Yes, I think you're correct. There's also some action out west. California has taken some new gun control measures, and Governor Gavin Newsom signed them. One that there's a court filing over is this advertising ban. Can you tell us a little bit about that?
Yeah, they banned or they're targeting advertising that is intended to be targeted at children, or could reasonably be viewed that way. And the governor, in his public speech about this, was pointing to things like the JR-15, which is this scaled down version of the AR-15. It's not an actual AR-15. It's a .22 rifle that's made to look like an AR-15, and it uses provocative branding, probably with the express purpose of getting sort of outrage attention from people like Gavin Newsom, the governor of California, because there's like the skull and crossbones with a pacifier sort of branding for this gun. Now, the gun itself is just literally a semi-automatic 22 rifle with a special integrated child safety lock that comes with a one round magazine when you buy it. But because it looks like an AR-15 and it has this provocative branding or trolley sort of branding, that's the center of this sort of law. But that's been challenged by the Firearms Policy Coalition and it's really kind of more of a First Amendment challenge. It's First Amendment.
It's actually not. Mm-hmm. But yeah, it's filed specifically based on the First and 14th Amendment, correct?
Right. Sure. Yeah. Yeah. The equal sort of due process, and they're using incorporation to challenge this under the First Amendment because it's a restriction on speech, effectively. But there's also another case out of California by, I believe it's FPC, if I'm remembering correctly. They do a lot of California litigation, but and I believe this one was filed with the California Rifle and Pistol Association, which is the NRA affiliate there, challenging the assault weapons ban.
Yes, and for the record, that the Second Amendment Foundation, SAF, filed the case on this child advertising.
Right.
Thing that we were just talking about.
Good catch there. Yes. So these are some of these groups that we're talking about here are the most active gun rights groups when it comes to litigation. GOA, FPC, SAF, yep. NRA. NRA usually working through its affiliates. The New York State Rifle and Pistol Association is an NRA affiliate.
Yes.
That won that Bruen case. So important to note who's doing this sort of work across the country, but. They're challenging the assault weapons ban. Now they're using the Bruen decision in that case as a reason for why the outcome should be different than previous challenges, right?
Yeah, and this is an interesting question because I feel like. These cases are going to deal partly with precedent from Bruen, but also partly precedent from Heller to some extent, right?
Yeah, Heller. Bruen builds on Heller, so it makes sense.
Yeah,
but they're using that common use standard that Heller spoke at length about when it came to banning handguns. The AR-15s and similar firearms, what the industry calls modern sporting rifles, what a lot of gun control activists will call assault weapons. Sort of these terms have kind of mushy definitions to them, especially assault weapons. The definition varies from state to state where these bans exist. But AR-15, if you're thinking of AR-15s, the industry claims there's 20 million of those in civilian hands at this point. So they're extremely common. They're the most popular rifle in the United States, that category of rifle, or that style of rifle, the AR-15. And so, a lot of the arguments, but this is not a new argument, but a lot of them have relied on this idea that Heller articulated about a firearm being in common use for lawful purposes. You just can't be banned outright as a category. And so that's what they're relying on in Bruen adds this new historical test, or a more explicit historical test, which, it'll probably be difficult to find a historical analog to assault weapons bans that dates back to the founding era. Now, obviously it doesn't need to be they don't literally have to have an assault weapons ban, an AR-15 ban back in, 1792, because the AR-15 didn't exist back then, but you'd have to find some sort of law that was similar in nature to ban a very popular firearm in the way that these bans do. And I think that's a high bar. Although we did talk to two experts for this. Our intern, Eric Eva, wrote this story on the assault weapons ban piece, and he got interesting comments from two different experts. I think it was Professor Blackwell argued basically that the Bruen standard makes upholding these laws much more difficult. But we had Professor Robert Leiter from George Mason University, who's also a constitutional law expert, argue that perhaps this doesn't change, or at least this particular argument about the common use standard might not be successful. And his argument was that these laws have been upheld under a couple of different kinds of reasoning, not just this two-step standard that the Supreme Court has explicitly cast aside. So, well, I guess there's some disagreement there, even among your sort of pro-gun scholars. I would say both of those sort of classify in the pro-gun category, but they have a different take on how successful these will be.
Yeah, I do think it's a really interesting question. So New York has this assault weapons ban that FPC is challenging, and it seems to me like FPC's case is quite strong when you point out that these guns, these quote unquote assault weapons, are really rifles that are in common use, that aren't more extreme in some way, rocket launchers, automatic rifles, that sort of thing. And yet this, to me, I look at the common use standard and I think, yeah, that should invalidate New York's law. But post Heller,
we should clarify that there's two lawsuits against the assault weapons ban, one in California and one
New
in New York,
California.
So just to be clear, there's several of these going on now in the post Heller landscape.
Yeah. Well, so that's the
and
thing,
then there's
right?
another
So
one
to
that was
me,
GVR in Maryland. So the Maryland's assault weapons ban is also now in a post Heller fight, because it was the court literally sent that back down for reevaluation. But go on. Sorry.
I do think it's an interesting question. Why weren't all of these invalidated after Heller in 2008? Like, we're talking about the world of post-Bruen litigation, which, the ball has been moved because of the two-part test being changed and stuff. The ball has moved in a pro-Second Amendment direction. But part of me wonders why the ball wasn't far enough in 2008 to invalidate these kinds of things anyway. I think the argument there is from gun rights advocates is what you saw in Bruen, right? Which is that these lower courts, a lot of them, especially in the more blue-leaning districts, areas, circuits, they use the two-step standard, the two-step review, to just uphold all of the gun control legislation that made it to their, to the final level of appeal. And so now that the court has said, well, that standard doesn't work, I think it opens up renewed scrutiny of these bans that, is going to be much harder for the state to justify under the Bruen test, basically. And so, but as Leiter pointed out, it's not impossible that they could withstand this scrutiny, I suppose. We'll have to see. I guess that's part of how these lower courts respond, and then how the Supreme Court responds to them is really going to tell you everything. Because that was the problem with Heller. At least that was the long-term critique of it was, well, sure, they made this landmark decision, but then when the lower courts did what gun rights advocates argued was ignoring that decision, basically, the Supreme Court didn't take up any of these cases outside of the stun gun one in 2016. And so they just kind of let it fester for a decade, 12 years, really, since McDonald, the 2010 case. But and that's why you didn't see these assault weapons bans getting struck down in that time. So that could happen again, just because the court issues a ruling and even gives out explicit instructions on how to decide Second Amendment cases moving forward. It doesn't mean that lower courts will follow it to the way that Justice Thomas or gun rights advocates want them to. And so,
plus this new standard that relies on historical tradition is a fairly there's a lot of subjectivity in there. You could probably look at Bruen, and if there had been 6 liberals instead of 6 conservatives on the court, even under the exact same standard, you might have come to a different conclusion about whether or not New York's May issue law was had historical analogs that would justify its existence, right? So you're going to see that fight continue, I think, and it's going to determine a lot of what happens. And speaking of Heller, by the way, we had another story. Yes, we talked to Heller. Heller is not just the name.
Heller is a person.
Yeah, it's not just the name of a court case. He's an actual person who's still around, and still extremely active, as you might imagine, in gun litigation. And so I spoke to him about the Bruen ruling, which is basically it's a descendant of his case. That Heller decision is a landmark decision for a reason. It was the first time the Supreme Court recognized an individual right to keep and bear arms was protected by the Second Amendment. And the Bruen decision is a direct descendant of that. And so he was, he said that was, a good way of characterizing it, and that he is not done fighting DC over its gun laws. This is a guy who was, he's motivated by, there were several shootings at his home on Capitol Hill in the 70s. And so now that's sort of what drove him to become more interested in firearms. And then he challenged DC's total ban on handgun ownership in 2008's case when he was he was actually a police officer at the time, or a special officer. He worked at the Supreme Court's annex actually when he filed that case, and he's filed 4 more since then. Some winning, some losing. Actually, this Bruen standard that relies on history and tradition, that actually came out of a Kavanaugh dissent in Heller's second case that was challenging DC's assault weapons ban. Now Heller lost that case, but he's since won other cases, or at least forced. He actually just recently forced DC to rework its ghost gun ban successfully through challenging it legislatively. He also was able to change their registration process and the rules for that in the wake of the first Heller case. So, he's been very active and fairly successful for somebody who's, filing federal court cases. And now he's back again with another case dealing with, there's a limit on how many rounds of ammunition you can carry on you if you are licensed to carry a gun in DC. You can only have basically 2 magazines for your firearm. So, and then there's a cap of 20 rounds total. So if your gun, the magazine only holds 8 rounds, well, you can only carry 16 rounds. But if my gun has a magazine that holds 10 rounds, I can carry 20 rounds. But he's challenging this whole structure as unconstitutional in the wake of Bruen. So, that'll be interesting to see how that plays out and what DC does. A lot of times DC's tactic has been after they lost in Heller and created, a landmark pro-gun decision that a lot of gun control activists really dislike, obviously. They've been less willing to fight these things all the way to the Supreme Court. That's why DC has a shall issue law. That's why the landmark case here was New York State Rifle and Pistol Association v. Bruen instead of Wren v. DC, because Wren challenged DC's gun carry laws and won, but the DC decided not to appeal and instead just adopted a shall issue law that now is being used as something of a model for the rest of the May issue states now. But so it took a couple years longer to get to the same result, but DC didn't want to be the one on the hook again. And so it'll be interesting to see how they respond to Heller's new suit. There's also a suit about carrying on Metro, on public transit here in DC.
Yes.
There's a separate suit filed by the same lawyer, George Lyon. We talked to him in this story as well. You guys should check it out on the Reload. But that's also being challenged in New York. New York has passed a similar restriction on public transit. You can't carry guns on public transit. Obviously, this is a huge problem for anyone who doesn't own a car and wants to carry a gun in public.
Like me.
And like a lot of low-income people as well, right?
Well, I was about to say, this is something that seems to basically
a lot of minorities
target
too.
poor people, essentially.
Yeah. Mm-hmm. And so it disproportionately affects minorities as well in these cities, like a lot of these gun restrictions do. But